Good evening, everyone, and welcome to our next CzechCrunch Shine event. My name is Clara. I am the founder of our CzechCrunch Shine community, and I'm so happy to have you all today here with me. Today we'll be discussing founders' first year from the legal perspective, and we are joined by the wonderful Katarína from Sparring.io. Before I invite her to our stage, I would love to tell you just a few words about our community for those of you who are joining us today for the first time. So CzechCrunch Shine is a startup community that is locally here in the Czech Republic, and our mission is to truly support and empower founders who are just on the beginning of their startup journeys and are looking to build and scale an amazing business. So what do? We organize online and offline events like the one that you're joining today. We have our monthly startup newsletter. We help startuppers find interns for their companies. We have a community on Facebook. We do a lot of interviews. We also have a mentors network, which I'll talk a little bit more about later. And we do a lot of networking and educational activities as well. On our events, we always try to make sure that we combine the main three pillars of our community, which is education, inspiration, and networking. So far, we have hosted over 5,000 people on our events in the last year. So I'm very excited that we're kicking off this year with an amazing event like this one. As far as our mentors go, if you go on our website, which is czechcrunchshine.cz, I'll share that link with you. You can find mentors from these amazing companies, and all you need to do is just click the button, get in touch, and you can get in touch with mentors from these epic companies. And I mentioned we have a Facebook community. So if you search Czech Startup Community, this is where you'll find us. We have over 1,200 members actually at the moment. And this is sort of the safe space we created for all of our members to join us there and ask questions, be informed about our events and different initiatives, share cool resources, etc., etc. Yeah, so I hope to see you there. All right, that's it for me. As promised, a quick few slides, and I would love to give my word to Katka now, who should be with us already here on the stage. Kati, can you hear me?
Hello, hi everyone.
I cannot hear you. I'm not sure if this is on my side. Let me quickly check.
Okay, how is it now? Okay, I can't hear you now, by the way. Still can't hear? Okay, how are things now? Can you hear me now? Okay, good. So let me start. Let me share my screen first. So hopefully you can see my screen now. So yeah, this is today's topic. Thank you everyone for joining today. Thank you, Clara, for having me. Thanks everyone for finding time and some appetite to hear something about the law on a Tuesday evening. Let me just promise that I'll try to make this as practical as possible and not focus on too boring legalities. So just to introduce our company, Sparring, we are lawyers. We provide the legal and strategic services for innovative companies. We have background in startups ourselves. We started as an internal legal team of a technological startup, so we can imagine pretty easily how day-to-day life or startup look like. We provide services in Czech Republic, Slovakia, but also in the US. And we also have developed our own legal tech product focusing on registration of trademarks that is called Trama. So I personally, after finishing the law school, I worked for 5 years in technological startups. And at Sparring, I focus on international clients, Czech and US. Sometimes I work with Slovak clients as well. And I mostly do commercial contracts and corporate law. So today we'll talk about these three main areas. The first, people in your company, first, money that you can receive in your startup, and potentially some issues that you can come across with. If you would like to learn more about any of these areas, feel free to check our playbook that we just published online, where you can learn a bit more. So let's take a look at the first area, people. This might be the most important area, and of course, the first people in your company are the founders and your first team members. So on the side of the founders, even if you can, of course, be a solo founder, or there can be more of you. In each case, it definitely makes sense for you to separate your personal life from your business life. And this can be easily done by incorporating your own company. This will be something that will be definitely expected by your investors, but by your customers as well. And for you, it definitely adds you additional level of protection from any liability that might occur. So what to incorporate, what kind of entity to incorporate? If you are in Czech Republic, Slovakia, definitely the easiest structure to establish is limited liability company, SRO in Czech. Easy to set up, easy to maintain, and offers everything that you will need in a startup. If you are incorporating in the US, the most suitable form would be corporation that has shares. That is also quite easy to set up, and you can even set it up from Czech Republic, so you don't have to be physically in the US to set up a company there. When we think more about the people, about the founders, and this will apply especially if you have multiple founders, but this topics are also discussed when you have investments, when you receive investments, and you have to agree with your investors on these topics. So this area is regulated by Shareholders Agreement that you will definitely have when you have investments. But of course, if you're at the very beginning of your startup journey, you have just one other co-founder, it doesn't necessarily make sense for you to have 20 pages shareholders agreement, but you should have at least a summary of these terms written up somewhere, maybe in an email that your co-founder confirms, and you have some kind of document to refer to where these points will be summed up. So what to find an agreement on and what to include in such a shareholders agreement. That would be definitely vesting of the founders. Usually the vesting term is between 4 and 5 years and works as a reverse vesting. That means that if your co-founder leaves the company before, let's say, 4 years, they will have to sell you back portion of their equity. So it makes sense for them to motivate them to stay with the company for a longer time. And if they leave early, this needs to be taken into consideration. Then another useful clause is bad leaver, good leaver clause that set out the rules for what happens if the founder leaves on good terms, or if the founder leaves because he or she is maybe stealing the intellectual property in the worst case of the startup and using it for his or her own product. Another useful clause is non-competition that says that during the time that the founder works for the startups and for 1 to 2 years after, they are not allowed to work for a competitor or work in the same industry where they would be using the know-how and the intellectual property developed in your startup. Another very useful clause that will be included should be included in your incorporation documents, especially if you're incorporating in Czech Republic, that is right of first refusal. That means that if your co-founder is selling their shares, they have to offer you the shares in the first place. So you have the ability to buy the shares. This gives you control over who will basically hold the shares in your company. So this is something to definitely include in your incorporation documents. If you take a look at the team, what is important here, even if your first team members are your best mate that you've known for 20 years by now, you unfortunately have to have contracts in place with them, especially when you want to make sure that the intellectual property that they developed is transferred properly to your company. So in certain cases, without the contract, the rights to the code that your developer developed for your startup is not transferred to your company if you don't have the proper contract in place. So keep that in mind. This is something that the investors will definitely check when they are investing. So what kind of contract to have in place? You have two basic setups that are applicable in Czech Republic, Slovakia, and US as well. That is independent contractors and employees. Independent contractors, this setup is more flexible and cost-effective and is suitable for computer developers, designers, these more, let's say, creative roles. And employment setup could be more suitable for operational roles, such as finance assistant or HR specialist. And as you know, with employment, this is more regulated area and is more expensive for the company, as you have to pay social security insurance, health insurance, and tax advances. What do you have in your arsenal is equity compensation. This isn't such a secret in startup world. This is quite common and market standard. And what equity compensation does is that you are able to make your team members your co-founders. You can give them a share on your company that will allow them to participate on any profit from exit event or any profit that you generate at the end of financial year, if you get to that point. And this gives them the sense of ownership. This motivates them definitely, and it also allows you to compensate for potential lower salary that you are able to provide to these team members in comparison to their market standard salary. So you are able to attract the best talent on the market. Equity compensation in the US known as stock option pool, or you might have heard the abbreviation ESOP used in Europe. This can be implemented in Czech and Slovak companies, in LLCs as phantom shares. That is the easiest way how to do it. In the US incorporation, the most common way is stock options. So let's continue with the first money. It's hard to say what will come first, whether investors or customers. The first money in the startup will most likely come from the founders or the FFF, friends, family, and fools. And the investors will definitely be interested in your customers as well, whether you have them or not. But they don't necessarily have to see a lot of paying customers when in the early stages, but they need to see at least some traction and some product market fit, of course. So what kind of customers you have defines, of course, your business model and also the legal side, let's say. So basically, there are two basic models. You do B2B, business to business, or you are in a B2C, business to customer model. When you have customers who are natural persons, who are individuals buying your product for their own personal use, not for their job, for their company, they might be legally falling under the category of consumer. So here you need to know that consumers are protected under EU law and there might be some rights that they will have, and that will impact your legal documentation, also some rights and maybe customer care that you provide. Another thing to keep in mind is data protection. We all heard maybe by this point too much about the GDPR, but the thing to remember here would be that this isn't that complicated to implement at the very beginning. And when it comes to basic GDPR policies and compliance, but it can make your life easier if you implement this early on, rather than collecting a lot of personal data without legal grounds, consents, and then trying to rectify the situation years after you started. So when it comes to contracts with your customers, you either have, let's say, a specific contract for each customer that you have, or you have terms and conditions that are on your website, and your customer accepts these terms just by click on a button. The thing to remember here is that even your terms and conditions are important, and it is not just some set of instruction on how to use your website. These terms constitute the contract that you enter with your customer. So you need to pay attention here and describe your business model quite in detail here. Whether you have terms and conditions or you have individual contracts with your customers, there are a few things to keep in mind, definitely. Maybe the most important one would be the payment, obviously, and the payment terms. For example, if you provide services for 1 month and your customer will be paying you after that first month, but with 30 days payment period on the invoice, you have to think about the fact that for 2 months you will be without the payment from that particular customer, and this can of course negatively affect your cash flow. Then another thing to keep in mind would be warranty. Just one thing to remember here, sometimes if you are selling physical products, you have to provide some warranty because of consumer protection, but you should never provide or some wide warranty for a software. If you are selling software products, you know that some bugs will always occur, and you can't say that your software will work without any defects, bugs, or alternations for 5 years. Another thing to remember, of course, is termination. You need some flexibility here, and you need to keep in mind that termination terms needs to be balanced. So a quick overview maybe of investors and investment process. This is of course quite wide area, and I believe you've heard a lot if you ever attended some of CzechCrunch event. They are also invited few investors here, so it's great to hear directly from them. Maybe just to summarize the types of investor that you can meet. I already mentioned the friends, family, founders. Then you have the accelerators. Here you need to check whether the accelerator is really bringing you the value that you expect, especially in case that they are asking for equity as a compensation for your participation in their program. Then you have angel investors that will be high net worth individuals investing their own money. They can be a bit more flexible and faster than VCs in some cases, but they are also professionals and will have certain expectations and processes that they are already used to. So you need to take that into consideration. And of course, VCs, there are typical players on the market. What is also important to keep in mind is that if you are raising funds abroad, or even here in Czech Republic, some funds operate with public money. They have some state grants, and they will have some requirements for where you place your seat, where you are incorporated. Some funds from Slovakia, Poland, Czech Republic requires the company to be incorporated in their state. And also some US or UK VCs might ask you to incorporate in their jurisdiction, in their state, just because they're used to that jurisdiction and they have some requirements from their investors. So this can happen. This is quite common, but you need to check whether this is something that will work for you. And of course, corporations. Some corporations have their investment branches. You can gain interesting partner in a corporation. Just remember that the investment process and also your day-to-day life can be a bit more complex, as the processes in corporation can be more rigid. When it comes to investment mechanisms, so you know that the investment process has several stages, from you first reaching out through warm intro, ideally to the investors, sending them your pitch deck, doing the pitch, meeting the partners, then maybe starting negotiating the term sheet, and sometimes in this stage also the due diligence process will start. So what the investors will check is definitely your product, its technical side, product market fit, traction, how it's doing with customers. Then your financials, and also the legal side. And this is the time where the work that you previously invested in setting up your documentation will pay off, as the investors will check the contracts with your customers, the contracts with the founders, the contracts with the team, especially whether the intellectual property of the team was properly transferred to your company. And if they found that there are any issues, you will have to rectify the situation before they invest. And this can prolong the investment process and also cost you some money at the time where you are waiting for the investment. So maybe your runway is a bit short at that point. So it's important to keep this in mind and be able to progress swiftly with the investment, and focus on the legalities even before getting to this stage. There are two basic ways how investments are done. This applies to Europe, Czech Republic, Slovakia, and US as well. And these are convertible loans or equity rounds. There can be some other mechanisms, but they're quite similar to these two groups. So convertible loans are often used with early stage startups. The documentation here should be simpler than as in equity round. And the main idea here is that the investor doesn't become a shareholder in your startup right away. They will provide you with the money, and in certain cases, such as you raising another investment round, or your exit, or some period lapses, the investment will be converted into equity. In case of equity round, the investors are becoming the shareholders in the company right away. They are buying the shares in your company. The documentation is much more complex, and it makes sense to use these mechanisms for later stage startups. So, what could be the first issues that you can come across with? Not trying to spread any panic here. The whole point here is just to point out a few things to keep in mind so you can avoid these issues. So, on the side of compliance, what you need to keep in mind after you incorporated your own company is proper accounting and paying your taxes properly. For that, you should hire a accountant. The costs shouldn't be too high, especially if you don't have too many employees or your structure isn't too complicated. Then this investment is definitely worth it, because you don't want to get into any issues with the tax authorities. Then if you work in an area such as finance, healthcare. You already might know that these areas are regulated by law, so it makes sense for you to check whether there are any specific licenses or other regulations that would apply to you. You can start with the research yourself, and then just after you realize there is some complexity, you can also, of course, ask for help from lawyers, but the initial research you should be able to do yourself. Then there's corporate governance. So this will depend on the type of entity that you are incorporating. But to keep in mind here is that in case of Czech or limited liability companies, you will have two main functions or bodies. You have the General Assembly, where all the shareholders meet and decide on some specific questions regarding the company, and then you have the managing director who acts on behalf of companies, signs the contracts. And each of these functions have their own rights and responsibilities. So in the US, in corporations, you have the equivalent of General Assembly, that is Board of Directors, and the equivalent of Managing Director would be the officer. And again, the Board of Directors need to approve some acts, some contracts entered by the company in order for such acts to be valid and effective. So on the side of disputes, what we often see are some unnecessary disputes over intellectual property, especially your brand, the name of the product that you're using, your logo. And what we see is that the companies check whether the domain is available. They set up their SEO, PPC, and then they receive some official sounding letter saying that they are not able to use that name for their product because somebody else already has a trademark for that name. So what can be done to avoid this situation is that when choosing the name for your product, you should also check whether a trademark hasn't been already registered for that name, and then register the trademark first, so you can also prevent others from using that name. The other source of issues in the area of intellectual property is also author's work, or the thing that I mentioned several times, that it is the people who will have the rights to anything developed for the company in the first place. So your computer developer is the owner of the code that he or she developed for you, unless it is transferred to your company. So there has to be a proper contract in place for that. So this is something that is called out by the investors that can cause some issues with the customers. So you need to make sure that the IP is transferred correctly in every stage. Of course, the most common source of issues and disputes are the people. In case of startups, the investors or the team. And my advice here would be just to try to avoid these disputes, of course. And that is when all the paperwork, all the contracts can be useful and used as a source of truth, as a source of knowing what you have previously agreed on and what should be done in certain situations. So I don't believe that contracts should be something that is used in a court as a basis of a lawsuit, but as something that is used to prevent any disputes. You should be investing your time and energy into your product and into growth of your company, rather than going to court and arguing about something that could have been easily prevented. So that is all from me at this point. As I mentioned, if you would like to learn more about any of these topics, feel free to check out our playbook.
Awesome. Thank you so much, Kati. Can you hear me all right?
Yes, it works.
Amazing. Great. I got a few questions in the direct messages here, so let's kick them off. If anyone will have any other question, please, you can either use the chat or you can raise your hand and you can come up to the stage and ask us directly. So the first question, Kati, I have for you is, what are the most common mistakes you see that the first-time founders actually make, sort of the things you then sort of have to clean up when they start working with you?
That is actually the thing that I've mentioned several times, and that is why I mentioned it, is that the intellectual property is not transferred correctly from the people that come up with the intellectual property, that come up with the ideas, that they develop code, that they do designs. And why this is so important is that this is actually the value in the company. So the startups usually don't build anything tangible. The value of the company is in the intellectual property. And often the founders don't have any IP transfer documentation in place, nor the first teammates, as they have some close personal relations. So this isn't considered necessary, and then this can be an issue at the point of investment, definitely.
Absolutely. Because then once the investor steps in and they see that the company actually doesn't have any value in terms of what they've built, right? Because all the team members are the owners, then they probably would not invest. So I can absolutely agree with you and imagine how complicated this could then become. Another question I actually had for you was, what's the best time to open an option pool? I know there are a few different, stock option pool and ESOP, like all the different terms, but when is like the, if we put aside the actual process and what it would look like and the form, what's the best time to actually start thinking about this if you are a founder and you are looking to share stocks with your team?
So I don't think that you can do this too early. Even your first investors would like to take into consideration your equity compensation pool, so they won't be further diluted by you giving equity compensation to your employee. So this is something that is definitely included in the first investment documentation, but it has also its practical reasons. So when you are hiring your first team members, most likely you're not doing so great on the cash flow side. So you probably are not able to pay them too much. And what you can really offer your team members is the equity compensation, and compensate them for the risk that they are taking joining your company so early, maybe losing some money on their compensation in comparison to some big corporations, for example. So this can be a motivation for them, and maybe even the only way how to get these people for you as the founder. And maybe a side note here would be that if you are incorporating in the US and you are granting stock options, then you have to take into consideration the strike price, that it will be lower at the beginning of your company life. So in such case, it makes sense to grant the stock options as soon as you can.
Absolutely. And I remember if you're in the US or you have a US entity, you actually have to have a valuation if you're granting stocks to your employees, right? So that's also like a good thing to be aware of, because by the time you go through the whole process, your employees might be a bit sad that they still didn't get their stocks. So I think it's good to be aware of this in case you have sort of the hybrid model of having your company here and in the States. I think this is a good one to know. I know you recently published your playbook, and I love all the supportive materials you're doing with Sparring. So another question I had come to mind was if you actually help startups with the legal processes, sort of as not only to check the contracts, but sort of as their partners in the process. And kind of a follow-up to that, if yes, from which stage can startups actually approach you to help them with this, with this whole funding due diligence process?
Any stage works for us, definitely. And we do have clients that we worked with on incorporating their first entity in Czech Republic, let's say, then working on the first contract with the team. So we are able to build, we are able to help them with building this whole legal structure that can be a good basis for them to build their further growth and their success on. So we are more than happy to help at the very early stages as well as later stages. So we have clients from all different stages, and I have to say we enjoy all of them. And it's quite fun to be at the very beginning and try to figure out what will work best for that particular company. It's not necessarily one size fits all, although there are some market standards, of course, that can be applied. But yeah, each company has its own problems, requirements. So it's quite fun at this stage, actually.
Nice. I actually, from our investor panels that you also mentioned, I always ask about the due diligence, and I think every investor said what you have said, and that is that it's always a little different, even though the companies might be very similar, in a similar stage, similar amount of investment going in. There's always some sort of hidden skeleton, I would say, that needs a bit of solving. Yeah. Absolutely. Great. Since we are talking about investments, what are some of the red flags or mistakes that you have maybe helped the startups to discover when working with different types of investors, or in terms of the legal documentation when it comes to investments?
So what we've seen quite often is that the cap table is a mess a little bit. That means there might be some old founder that already left the company, but there wasn't any shareholders agreement in place, and they still hold a significant amount of equity. And maybe the relationship now isn't so good, so it's hard to solve this situation. So that's one thing. Also, what happens is, again, the issues with the IP that needs to be solved at the point of investment, definitely. And again, if you have a former developer who developed a certain significant portion of the code, but you are not in touch with that person anymore, and you need to reach out to them after 2 years. Hey, by the way, can you sign a contract here for transferring your IP that you developed for us? The investment documentation aligns with the term sheet. So that is the first thing that we always check. And mistakes can be made on both ends. Sometimes even startups can think that they can negotiate something different that they agreed on in the term sheet than in the final documentation, and that can't really happen. So that I don't think that any investor would be too happy about that.
Absolutely. I think that is quite a common mistake if there is no shareholder agreement and sort of no clear boundaries, I would say, between the founders set from the beginning, that this could then lead on for months, even years, right? So yeah, absolutely recommend getting a lawyer to help you out from the very beginning. And what about from the investor side, right? Were there any examples of red flags that you maybe found from the documentation from the investors, whether that was in terms of equity versus money or some other specific conditions that you might have discovered for your clients, e.g. the startups?
Definitely, yeah. So the most important terms should be already known and agreed on in a term sheet. So when it comes to the amount of equity that the investor is getting, that should be clear from the term sheet. And what is also important is that the founders are able to calculate what that means. So if you have these equations here and setting valuation caps, discounts, different kinds of valuation for different scenarios that can happen as well. So the investors have to do their math and calculate what this really means. And so these basic terms should be already agreed on. Sometimes when you see the full documentation, there are some areas that haven't been covered in the term sheet, and that can bring some additional negotiations, and that could be the question that needs to be approved by the investors. So some reserved matters that needs to be approved by the investors. Or what we also seen that was in Series A, there was a long list of representations that the founder had to provide, saying, for example, we are not in any kind of dispute and we won't ever be, or something like that. And if the founder broke any of these representations, there were quite high fines in place. So that is the point where the founder needs to be quite sure about the due diligence process and what happened in the company and what's happening in the company at that point, because he's signing that, yes, all these things are okay, we are good, we have all the licenses that we need. And if not, there can be some fines, contractual penalties, to be correct, for the founder or for the company.
Absolutely. So it's always better to have multiple eyes go through every single document and to take your time when raising. I know we have a lot of early stage startups as well. So I think one of probably the most common questions, and you probably touched this on a little bit in your presentation, but what would be your answer to the question, do I actually need a company right now? Let's say there are 2 or 3 co-founders just starting to work on their product, whether it's a physical or a software product, and they know it's going to take them 6 months or a year to actually put things together before they're able to even start testing, selling, or even fundraising. When is the best time, for this sort of scenario to actually invest in establishing the legal entity? Because once you do, you're an official company, you need to get an accountant, right? So there's a lot of responsibility. So what would be your recommendation in terms of like the very early stage ideas/projects?
I would say at a point that you are ready to publish something, to create your website, for example. So at the point when you start to go to the market, so you are able to present your ideas, because already at that point, what is important about companies is that is the place where you pool all the IP. Without that, the IP is in the head of each individual founder or team member, and they can walk away at any time, and the other founders have no means to force them to come back and work with them on the project that they were working on before. So at the point that you already have something concrete, something that you want to offer to your customers, it makes sense to set up the company. And what definitely should be the point, even if you don't do that at this point, but definitely at the point when you are issuing your first invoice or entering into any kind of contract with any customer, and that can be some MVP testing model, just doing some proposals, offering them free trial even. At that point, it definitely makes sense to have that additional level of protection for the people and also pull the IP in a separate company. And you don't need to worry about the cost that much. The initial cost shouldn't be too high, and even the costs of accountants should be quite low. If you don't have any employees, nothing is happening in the company, they need just to register you, and that should be also, you shouldn't be too worried about the cost at that point.
Absolutely. Do you actually help and recommend your clients or early stage startups some good accountants they can work with?
Yeah, we definitely do that. We also offer a CFO service where we work with local accountants. And on top of that, we also provide additional services such as forecasting, budgeting for the companies. The good thing about accounting is that it's not, and the CFO service as well, is that it's not just about fulfilling your legal obligations, but you have to know how your company is doing. And this is also something that we see with startups quite often. They don't actually know how long their runway is. They can check how much money they have on the bank account, but they don't know about the money coming in from the customers, the expenses that they can expect in the following month. So sometimes they are quite surprised when they take a look at their cash flow, and they're just guessing if they'll make it to the next month or not.
Yeah, absolutely. I think that's very helpful. Great. We have one more question actually coming from in the chat from Martin, and the question is, what are the pros and cons of an European-based team incorporating in the US versus in Europe?
So if I understand correctly, there is a team that is located in the Czech Republic, and they want to incorporate in the US. So this makes sense to do in case that you want to penetrate the US market. You have customers there who just needs to see a US entity rather a Czech or European entity, or if you want to fundraise there. But if you are just building your product, you are at the very beginning, it can create some additional complexity for you that you don't need. So if you are able to start with your company locally for practical reasons, you can do that. And if you are ready to move with your product as well to foreign markets, then you establish a separate entity in the US. You can connect these two. That's not so complicated. You are not created some complicated holding structure at this point. But still, if you have your entity in the US and there's nobody living there, then you can have some practical issues, of course. So you need to take that into consideration.
Absolutely. So would you say it's actually easier for the company to get established here and then do like a child company in the US versus establishing in the US and then doing a company here in the Czech Republic?
It can be either way, depends on where your team is located and what makes sense for you from the business perspective. The legalities can be figured out. It's not that complex, but it's definitely about where your team is located, where you're actually doing business.
Absolutely. And I think that because we actually were working together with Katka on a project where we had a similar case scenario. And I think that if you have a team locally and you then have an entity in the US, but most of your spending will be in Europe, then that might look a bit off the books. So I think, as Katka mentioned, if you don't have a team out there or if you are not going there anytime soon, it's good to start locally. And I think this was in your playbook as well. Always start locally and then expand. Definitely. Absolutely, absolutely. All right, we have time for one last question, which is in the chat as well from Imrich. So let me quickly read it. When allocating equity share for early employees or core team members, how many % do you suggest the founder put aside for the key people joining the company at a later stage? So how large should the option pool be? Or what's the recommended amount, or what have you seen in your companies?
Most often we see 10 or 15% in Europe. In the US, the percentage is a bit higher. It can be around 20%. And yeah, again, it depends on your plans for hiring, how much you have already spent for the founders as well. But 10 to 15% is quite standard for EU entities.
Absolutely. Absolutely. Perfect. All right. We're slowly running out of time. So if anyone has any other questions, I would definitely direct you to check out sparring.io. We have recently did a legal week with them. So even if you go on our CzechCrunch Shine social media, probably any account, you'll find a lot of helpful information they have shared with our community along with their playbook. So I definitely recommend checking that out. Katka, thank you so much for joining us today. It was great to learn a bit more about what are the first ups and downs, I would say, in from the legal perspective in Founders' first year. So thank you so much for joining us today.
Thank you for having me. It was great.
Amazing. All right. Thank you, everyone in the audience as well for joining us. I would love to quickly invite you to our next event, which is called Creating Inclusive Startup Culture. We are actually going to be streaming this one in 2 days on Thursday at the same time. I think we actually have a few Sparring clients here, so that's very, very exciting. So I hope to see you all there. And as mentioned, don't forget to check all our accounts or our website, czechcrunchshine.cz, to get in touch with Katarína, who is also a mentor there, or check one of our social channels for more information and updates. Thank you, everyone, for joining today, and have a lovely rest of your day. Bye.